I've been given the fun topics, the ones to talk about what are in chapters 6 and 7 of the Newport Manual. First of all, dealing with the means, and secondly, dealing with the methods of naval warfare. So we've had the preliminary information, but this is where we can find out, well, how do you do all of this? So same rules that we've had with the other lectures. If you've got a comment or question, please just let me know, and we'll deal with that as best as we can. And yeah, that's all the introductory sort of stuff. So here's the things that we will talk about during this presentation. First of all, this is a bit of a theme that we're dealing with here in terms of lack of absolute agreement, lack of precision for trying to find a universally recognised definition of what is meant by means for warfare. We've got some help is given by, at least by use of the terms in publications such as Additional Protocol 1, military manuals. We've mentioned that on the Stockton Centre's e-portal, there's lots of military manuals available. Some of those are also helpful in trying to get a understanding of what means might actually entail. But in the Newport Manual, if you look at Chapter 6, what we've primarily said is that when we're talking about means of naval warfare, we're talking about the weapon systems themselves, the weapons that are used as part of naval warfare. And this presentation is going to focus on some of the most common weapon systems. We're not going to go down into the detail of every type of shell or every type of missile or mine, but we'll look at some of the common ones and how they're used and the lawfulness of those weapons themselves. So guns, missiles, rockets, other projectiles, torpedoes, all of those are examples, and it's the effect that we're primarily concerned with. We don't go into any great detail, for example, with handheld weapons that might be arming a boarding party, for example, if you're undertaking belligerent visit and search. But anything that can deliver the effect, death, injury, damage or destruction, that's basically what we're talking about here. And remember, with naval warfare, that is the outcome that ultimately we're talking about. People are going to get killed, they're going to get drowned, ships are going to get sunk, weapons are going to be delivered against land targets, aircraft are going to get splashed, and so on. So it's a different mindset that we're talking about, particularly if you're more used to thinking about law enforcement or those types of activities where the law of armed conflict is not the applicable legal regime. Here in the law of naval warfare, we're very much talking about those types of outcomes. Some weapons, there are some restrictions placed on some weapons. This slide is a little bit busy, but it gives some examples of those. So we're going to talk about naval mines in a little while. There's a treaty, again, one of the old treaties from 1907 that deals with one specific type of naval mine, places restrictions on how those mines can be used. Customary international law, as well as some instruments, Geneva Gas Protocol from 1925, after the events of World War I, prohibits the use of poisonous and gases and so on, poison weapons. And then there are some general prohibitions picking up on what Martin was talking about before the break, where a weapon that causes superfluous injury or unnecessary suffering, damage to the environment. But look at these things too. There are conditions on all of these. widespread, long-term and severe damage to the natural environment. It doesn't just mean that there's a bit of pollution or something's burning. There's conditions that are placed on this. Weapons which are indiscriminate, and also a question to be asked, I suppose, about whether the weapon is one that just offends those basic principles of humanity. Now, with all of those restrictions, none of that precludes using a weapon simply because it might result in a rather messy death. So none of that precludes using a weapon, for example, being fired into a ship and people being burnt to death, people missing bits of their bodies and so on. That's not the effect of these restrictions. Okay, so again, just going back to the point that what we're talking about with naval warfare, it's going to result in some fairly savage outcomes for people. And you saw on the video that Jay showed earlier today, where weapons were being fired at people on whichever maritime feature it was that he was showing us. The fact that those people are going to be killed by those weapons, that's what is contemplated. So just using a weapon in a way that means that somebody is killed, something is destroyed, there's nothing illegal about that. And that's just a comment there from the ICJ 30 years ago now, talking about prohibitions of certain types of weapons because of their indiscriminate effects or because of their unnecessary suffering that is caused by them. This is in the context of nuclear weapons, but there's no overall ban just because that is the outcome. Okay, so in the Newport Manual in Chapter 6, we deal in some detail. I'll show you that in a minute. San Remo Manual, for those who are familiar with it, really quite limited detail, specific detail dealing with weapons. A couple of rules, 78 and 79, which basically refer back to earlier principles in the San Remo Manual. Doesn't go into much detail there. And then quite a lot of rules that deal with the specifics of using naval mines. Our approach in the Newport Manual was a little bit different. And this is different to what you have in the book in front of you, because this is the second edition. This is what we covered as part of the update to the Newport Manual in introducing or recognising some new weapons that we'd not included in the first edition. So I'm not going to go through in detail with all of these, but we'll look at some of them certainly as we go through. As I said, San Remo Manual, really not a great deal other than what it talks about in terms of mines in some detail. Okay. Another bit of law that is of relevance when we're talking about means of warfare is what's described as weapons law. And weapons law, for some of you who like doing study into these things, you can do courses, complete courses on weapons law and the requirements. A colleague of many of ours, Bill Boothby, has written a book about this, which is a very good reference publication for you. So what's the purpose of that type of law? Well, part of it is to regulate both weapons and the means of warfare that can be lawfully used during an armed conflict. Sources come from customary international law as well as some treaty law. We've talked already a couple of times this morning in both Jay's presentation and Martin's presentation about differing requirements that states have depending on their treaty obligations. So that's something that needs to be aware of as well. Also picking up on what Martin was talking about earlier, there's nothing explicit in relation to treaty provisions that says that the general principles in armed conflict on land are also relevant at sea. And I'm not talking about Article 49. We will get to that in a minute of Additional Protocol 1. So the fact that the weapon that you've chosen to use is going to cause that platform to sink and people to lose their lives doesn't mean that there's just an automatic offence towards some of those general principles. For example, unnecessary suffering. Drowning, I understand, is not a particularly nice way to die, but just because your weapon system is going to result in someone drowning doesn't mean that it's therefore there's a restriction or prohibition on using that weapon. Maritime environment, we've also talked about, Martin mentioned about the vastness, I suppose, of the maritime environment and some of the principles such as distinction and impact of collateral damage might not have such an impact on the weapons choice that you make when you're conducting armed conflict at sea. Having said that, there are plenty of places throughout the world where maritime traffic is restricted. Choke points around the world, various straits, Malacca Strait, Singapore Strait, entries into harbours, areas where there's a lot of shipping in the general vicinity. And so it may be that some of those general principles are relevant in some circumstances at sea as well. Okay, let's look at some of these weapons themselves. First of all, gunnery. Long been a feature of naval warfare, sticking a gun or two on a ship, and a large calibre one at that. There is some treaty law that we can look to, and I'll go through that in a minute. Hague 1907 has a little bit of assistance for us, Additional Protocol 1 as well. And using gunnery, certainly when you're directing the guns at targets on land, does bring into play the need to distinguish and recognise that there might be an effect on civilians and civilian population, simply because of the way you're doing those activities. So, going on, Hague 9. In 1907, the people who put together treaties were a lot more succinct than the people who have put together treaties 100 years later. So, Hague 9 deals with bombardment of undefended ports, towns, villages, dwellings or buildings, and starts off by saying if these areas are undefended, you're not supposed to be targeting them. That makes a lot of sense. We've talked about resources being finite. Militaries don't have unlimited resources available to them. You can see from Article 1 already there's reference to mines, naval mines, and just simply because those naval mines were in the immediate environment, is not a basis for bombarding a port, town, village, etc. Then goes on to say what you can target, and if there's unavoidable damage, what we would now call collateral damage, well, that's not going to be a area that would raise responsibility for the military commander as well. Convention talks about providing notice. So picking up the ideas of trying to protect the civilian population as much as possible. So after notice has been given, bombardment of these types of facilities can commence. Due notice, what is meant by due notice? Well, it can't be, for example, I'm about to start, you need to leave immediately and then start, straight away. It's got to be something more than that. I don't know that Article 4 has much contemporary relevance anymore, but it points to perhaps the way that warfare was conducted in terms of failure to pay contributions to your opponent. And this is the remainder of what's relevant in this convention. So very, very short. All necessary measures must be taken to spare the sorts of things that we know should be spared: civilian objects, sacred objects, places of worship for sick and so on, all of those types of things. So these types of restrictions have been around for a long time. And then if the commander can do it, give a warning that we are about to do something. And we've seen in recent conflicts there has been some evidence of this, not under this particular treaty, but just as general practice in a couple of recent conflicts as well. So the main points of Hague 9 are these: that give notice. There's nothing wrong with targeting military works in such a location. Civilian objects, civilian premises are not supposed to be the object of the attack. And if there is, however, damage to those incidentally, that's not going to be a problem. Nothing wrong with warnings. In fact, if you can issue a warning, that's probably to your benefit in any case, and you're not supposed to go in and pillage the place as well. Now, for those states that are party to Additional Protocol 1, it does talk about naval bombardment, naval gunnery, gunfire support, fires, whatever your term is that you wish to use. But it talks about it in a particular context. And it basically excludes this part of Protocol 1 from the application to naval warfare, except when you're dealing with land attacks, in which case the provisions in Protocol 1 dealing with the general principles that Martin has gone through are certainly relevant there. So apply to all attacks from the sea or from the air against objectives on land, but do not otherwise affect the rules of international law applicable in armed conflict at sea or in the air. And what that is recognising is that there are legal requirements and legal issues that arise at sea that are different and have different considerations to those that apply on land. So, what types of things do you have to be considerate of for land attacks? And it doesn't matter what weapon system you're using for this type of attack, whether it's shells, whether it's rockets, whether it's missiles. But if the effect on land, there are some precautions that are put in place. And those ones are the ones that Martin has gone through earlier. So an example of how this played out that involved my Navy a number of years ago was in 2003, when forces from a number of countries were going back into Iraq. Now remember, we're not worried about whether it was lawful to do that or not. That's not our question for us to worry about. What we're worried about here is, well, what about the attack? And there were landings that were going to take place on this peninsula here at the southern extremity of Iraq. Ordinarily, you would want air cover to support a landing like this. That's very, very common practice now, joint forces going in. Sometimes, however, the conditions in the northern parts of the Gulf in particular are not very helpful for using air cover, and that was what happened on this day. You had landing forces, British landing forces as well as American landing forces that were going to come in through the Alford Peninsula. The air support that was requested was unable to be of any use, and so a decision was made that a number of ships from the British Navy and one ship from the Australian Navy would provide the air support that was needed through naval gunfire support. They applied something that you will look at on that. Oh, that's just a bigger picture of where they were going. These waters are quite shallow up in this part of the world, reasonably confined, and so there was some sort of tight work required amongst these ships up here. You're going to deal with targeting tomorrow, but this process was adopted and gone through, and I won't talk any more about that now because you will pick that up as part of tomorrow's discussion. And here were the positions that the ships were placed in to try and... there is a slight error on this slide. You might notice that one of the arrows ends up in Iran. They were not taking the conflict into Iran. It's just that my skills at trying to correct this slight error when I resized it were a little bit beyond. But yes, do not think for a minute that they were actually putting the naval gunfire support into Iran. That was not happening. But what was happening, and this is a picture from HMAS Anzac, you can see the shell, the projectile, just leaving the weapon there. They basically spent about 24 hours supporting this landing force and providing that support. And the reports that came out of it were that this use of naval gunfire support was very, very well received by the landing forces. It wasn't so well received by the Iraqis. The Iraqis didn't like it at all. And the reports from the British Royal Marine commander of the landing force were that the constant ability to be able to use naval gunfire support shattered the enemy's will to fight. Basically having the 5-inch guns and other guns send their weapons over to the troops just made them realise that this was not a good place to be at all, and off they went reasonably quickly. The rounds were fired at military installations. The reports that were provided at the time, perhaps propaganda, but talked about the only things being destroyed were military objectives, that there was no damage to civilian infrastructure. Whether that is entirely accurate or not, I don't know, but the reports overwhelmingly were that military objectives were targeted, and that the accuracy of the rounds that were delivered from the ships, so even when they're slightly off, they just adjust a little bit, and then the accuracy of those rounds was very, very good. And that's, again, the quote at the bottom there, the success of the operation largely due to the aggressive use of these assets and the swift and lethal response. So calling them in, we're now heading this way, can you hit these coordinates? Yes, no problem at all, we can do that. So an example there from 20-something years ago now of using a dumb weapon. A dumb weapon that once it leaves the barrel, you've lost control over it completely, but getting the proper and desired outcome from that weapon. What about missiles? And a couple of examples here that we can look at from the Falklands Malvinas conflict in 1982. The first one relates to before the task force got anywhere near the islands. So the islands were occupied by Argentine forces. A task force was put together from the United Kingdom, and it takes a number of weeks to get from the United Kingdom to the Southern Atlantic. During that time, the task force, which consisted of 2 aircraft carriers, which had the Sea Harrier on board, as well as escorts, they were being intercepted at one stage by Argentine 707. And a 707 looks a lot like a commercial airliner because that's what it is, modified for military use. The concern of the task force commander, Admiral Woodward, was that this 707 had come out a number of days. It had found the task force and it had identified where the task force was going. And his worry was that there was going to be an airstrike on the task force, and if he lost one of his carriers, the chances of anything successful happening in the South Atlantic were reduced to 0. So he asked for permission to use his missiles and take out that target. And he got permission to do that. He describes in the book that he wrote after the operations had all finished there in the South Atlantic, and Britain had successfully recovered the Falklands, Malvinas. He describes how close he went to releasing missiles against that aircraft. Now, he also describes his decision not to release the missiles. His rules of engagement said to him that he could take this out as long as he had positive identification. Once again, even though he had aircraft carriers, being able to positively identify with eyes, seeing the target, was something that was unavailable to him for a period of time. He decided to just do a final check before releasing the missile. And he got his planning staff to just lay out a chart and just draw a track. Get out the parallel ruler, get out a 2B pencil and just draw a track of the aircraft. And at that point, he stopped the missile release. And he literally describes it from being minutes away from sending these missiles up. Eventually an aircraft was able to get off the deck of one of the carriers. It went up there and it found an aircraft, but it wasn't Argentine Boeing 707. It was a commercial airliner, lit up like a Christmas tree. And very fortunately for the airliner and for the Admiral, those missiles weren't sent on their way. They would have got the airliner. And as the Admiral says in his book, the Falklands would no longer be the Falklands, they would be the Malvinas, because he would have been ordered back to Portsmouth, where he would have then been court-martialed, and whatever happens to admirals who make big mistakes would have happened to him. Could he have used that weapon system? Would it have been lawful to use that weapon system? Yes. If all of those criteria were in place, it would have been. It might have even been an unfortunate accident, not unlawful, of splashing that civilian airliner. Fortunately, in this case, his sixth sense or something or other prevented that tragic outcome happening. But it also, I suppose, shows in this case the question that you might have about what does positive identification mean? Does that mean that you've gone through everything that you need to go through short of actually seeing with your own eyes? Can you rely on radar systems, on sensors? Is that sufficient for positive identification? In this case, he did take that extra step and saved a very tragic outcome against what all indications on board his carrier were telling him was this thing back again. And he had authority, a weapon system, absolutely lawful, use whichever sea-to-air missiles he had on board at the time. I can't remember what it was, but that certainly using that system in that would have been absolutely fine. I do know what weapon systems were used against these vessels. It was the Exocet missile. Whereas, he's gone home, our friend Adrienne from France. Thank you very much for supplying those Super Étendard as well as the Exocet to Argentina. But they were very effective in this conflict. The Exocet missile was very, very effective against ships like HMS Sheffield, which was sunk in the conflict. Is there any problem with using a missile against a naval surface unit? Absolutely not. Completely lawful to use the missile. The fact that people are killed and the ship is burning. Again, this was a vessel that was accompanying the task force. It wasn't a naval ship, but it was carrying a whole bunch of military once again, targeted, Exocet. It was sunk as well down there in the conflict. And more recently, we've had the use of missiles in the context of the Black Sea, where this vessel was sunk as a result of the missile strikes. And that was, of course, was the flagship of the Russian Black Sea Fleet. It's also now at the bottom of the Black Sea. So using the missile to target a vessel at sea during an armed conflict, perfectly lawful, regardless of what missile type you're talking about. We don't need to go into the detail of all of the different missiles. Other uses of missiles more recently in a couple of recent situations. We've had missile strikes in Syria. We've had missile strikes in Yemen. Conflict classification is not something that I'm dealing with here in terms of what was the lawfulness of those missile strikes, but they certainly did take place. And the Russians also used missiles more recently in the earlier Syrian conflict as well. So because you are targeting land objectives here, there are those additional requirements that weren't applicable for the targeting that took place in the Falklands Malvinas situation. So there are plenty of examples, both a little bit distant and recent, in terms of the use of missiles in naval situations. So in terms of thinking about guns, in terms of thinking about missiles, rockets and so on, there is some treaty law that is applicable, that can be used to guide some general principles. Additional Protocol 1 has some limited relevance if you're attacking land targets as well. State practice is also another area that can be used to work out what might be the limits on using missiles. But overarchingly, we're talking about in naval warfare, we're talking about the platform itself. And so when we're talking about the platform, these other concerns, the more general concerns that were talked about earlier, are really things that don't arise in the naval context. All right. Next weapon to have a look at is torpedoes. And again, we're not going to go through all the various different manufacturers and mark whatever we're up to now with torpedoes, but we'll have a look at the general considerations of torpedoes. And our starting question is, do torpedoes, are they a lawful weapon? And what's the criteria that we might think of in terms of torpedoes? How are they used? Where can they be launched from? They can certainly be launched by submarines. We'll see an example or two of that. They can certainly be launched from surface vessels as well. And they can be launched by aircraft as well. We've got a lot of example of use of torpedoes from World War I and World War II in particular, but more recently as well, in both the Falklands conflict and also much closer to us, the torpedo that appears to have been responsible for the sinking of the Korean vessel Shannon. So let's have a look at some of this. So unfortunately for Germany, I'm sorry, Wolf, but every now and then there has been an attack on a vessel that has had some consequences. As I think you mentioned the other day to us, there were some reasons to suspect that the passage of this vessel was not entirely above board, but was it necessary to sink the vessel using a torpedo? And 2,000 or so, what did they say on this, 1,260, whatever the number was, for the small amount of material that was on board the vessel, was in fact a lawful outcome of this behaviour. Another example where some torpedoes were used, there are many, many examples from the Second World War, of course. Another example here, a vessel that had a lot of prisoners on board. It was sunk. We will talk a little bit more about this perhaps in a later context in terms of what happened as a result of this sinking. Jay mentioned earlier about the history of naval warfare in this region. He neglected to mention that Australia was also involved. In fact, there was the ABDA task force. It was America, Britain, Dutch and Australian task force involved in the Battle of the Java Sea. And torpedoes were certainly used to sink a number of Dutch vessels. One Australian vessel was sunk. At least one American vessel was sunk. That was in the Battle of Sunda Strait. They got out of Java Strait. The Dutch didn't, sorry, Martin. They were sunk immediately. But the Australian and American vessels tried to get out of the area by going through Sunda Strait. Unfortunately, they ran into the Japanese landing force, who overwhelmed the Perth and the Houston very, very quickly. Torpedoes were used there as well. But prior to that, Z Force, Force Z. Force Z was the British sending out a battleship and a battle cruiser. HMS Prince of Wales and Renown. Okay, and the use of torpedoes by the Japanese here was signalled really the end of the battleship as the superior capital platform. Because even though both of those vessels were very well equipped with anti-aircraft guns on board. The Japanese, for the first time, were able to show how properly trained crews could sink ships using torpedoes launched from the air, and no air cover available for these two vessels, and this was a huge embarrassment to the British and the Allies in terms of failing to understand that torpedoes could be used from aircraft to sink vessels. After that, forever. In World War II, there were many examples of the use of torpedoes to sink vessels, and of course, from World War II, what we really saw was the emergence of the superiority of the aircraft carrier and the demise, really, of the battleship. Falklands was probably one of the most famous examples in reasonably recent times of using a torpedo to sink a large vessel. The General Belgrano was a General Belgrano was an old cruiser, but still a very capable vessel and threat to the Admiral's task force. It was intercepted by a British nuclear-powered submarine, and after getting approval to attack the vessel, that attack was launched. And torpedoes were fired at the vessel. A number of torpedoes were fired, at least one of which, maybe two, managed to hit the vessel and, unsurprisingly, broke its back, and it sank reasonably quickly with a significant loss of life. 300 and something, from memory, 300 and something out of the 1,000 or so crew. So nothing unlawful about the weapon. Questions were raised at the time, which to my mind are completely daft questions about the legality overall of attacking the vessel at that stage of the conflict. But the weapons system itself, the torpedo, no problem. No problem with using that weapon system at all. This one, more recently still, the Korean vessel Cheonan sunk 15 years ago. Commonly thought to have been a North Korean torpedo. So here, I got this off the internet. Here's some parts, Korean or torpedo parts that are on display in the War Memorial in Seoul. The Democratic People's Republic of Korea denies that they did this, but nevertheless, the evidence that was put together appears to be very convincing that this is in fact what happened. Okay, naval mines. We're talking about the use of mines at sea. And first of all, understanding a bit about naval mines and what they are. Here's one definition from NATO doctrine. But basically, something that's in the water that's trying to blow up your ship. That's about as simple as it gets. And there are lots and lots of different types of naval mines that have different ways of exploding and different mechanisms involved in terms of what's going to trigger their impact. So a couple of pictures to show some of those. First of all, you can have them in a fixed spot below the surface. Hopefully you don't know they're there, and you come along, you hit the mine, and it does its work. These ones are a bit more dangerous in the sense that they're just drifting around sea areas. A lot of use of those during World War II in particular, but also during the war with Iraq in the 1990s. A lot of use between in the war between Iran and Iraq in the 1980s, where locations of these types of mines not accurately known, and because they drift and free float, knowing where they are is much, much more difficult. Mines that sit on the bottom of the seabed and are activated either by some control mechanism, a signal, or perhaps by a signature from a vessel passing overhead as well. Similarly with mines launched from submarines, and these ones that can rise up based on a submarine passing in the near vicinity of the mine as well. It releases its warhead and goes off and looking for the mines. So in terms of the law, looking for the target, in terms of the law, the first question is, again, are mines a lawful weapon? And I don't think there's any problem with that. They can certainly be used in a way that is not consistent with the law, but the weapon system itself, or the weapon itself, fits within the category of lawful weapons. You've then got a different question that to some extent moves over into what we talk about in Chapter 7 and what I'll talk about once this part of the presentation is finished, in terms of the way that mines are employed. So just looking at the mine itself as a weapon, yes, no problem with it being lawful, but you can have an unlawful aspect in terms of how the weapon is actually used itself. And particularly in the case of those free-floating mines that I was talking about earlier, where one of the basic principles of distinction is not being adhered to, and especially if it's an automatic contact mine, i.e. if you simply hit the mine, it blows up. You've got no control over it. So that can be an issue. And importance, I suppose, of mines as a weapon was shown in the war between Russia and Japan in 1904 and 1905, where there was extensive use of mines, sea mines, in that war. And out of that came that one convention that we've now got, the Hague number 8. Where can you use mines? Yep, you can use them in your waters. You can use them, of course, where you're lawfully permitted to conduct your operations. So Hague 8, as we've talked about, deals with one particular type of mine. Now, a number of us have written about naval mines and have put forward the view that some of the principles that are in Hague 8 apply more widely to naval mines. Things such as no indiscriminate effect from the mine, that innocent shipping is not targeted by the mines and not disadvantaged, that if the mine, if the state that laid the mine loses control of it, that there has to be some sort of mechanism to disable its explosive function. And also the idea that if you have employed mines, you know where those mines are, and there's a responsibility once hostilities have finished to clear the area and not present a hazard to innocent shipping, as well as warnings. How many mines do you have to deploy to have a credible threat to shipping or to your adversary? How many? How many? What do you think? Huh? How many? I don't think you have to actually deploy any. You have to say that you have, because that's enough for people to be a little bit worried. You know, if you put a warning out that you've laid a minefield and you've got capacity to lay a minefield, you've got that capacity in your inventory, your adversary is going to be worried straight away. Did they actually put some mines here or not? If you deploy one and it hits something and it blows up, well, there's some pretty good evidence that you do have that capacity. But you don't need very many, and they're very cheap. They're a very cheap weapon in the scheme of things. So for many years, my country didn't have a mining capability. We had mine clearance and mine hunting capability, but for many years we didn't. And I think maybe 2 years ago, not very long anyway, 2 or 3 years ago, Dale or Rob, you can correct me, but it's very recent. Our government has finally realised that having this capacity to in our inventory is very important. And in this region that we're in, there are lots and lots of states that have mines, and some of them are quite basic, but they're very, very effective weapon. Since the end of World War II, the weapon that has destroyed the most naval vessels is sea mines. That's the weapon that has caused the most damage to ships. So very, very effective weapon. So that's what Hague lists out in terms of the use of mines. If they break free from a mooring, disable them. If you lose control, they become inactive. Know where you've put the mines, let others know. The areas that you can use them are those that we've talked about already for naval warfare. You can't... a question about using mines to prevent passage in straits and archipelagic sea lanes is still a little bit unresolved, because if you're using it to completely stop traffic, that's inconsistent with the rights that ships have for archipelagic sea lanes, traffic and transit passage. And then, remove them after it's all over. So, I think I've talked about all of those things for naval mines. And then, finally, in terms of weapons, in the Newport Manual, we then deal very briefly with a range of other types of weapons that we're seeing deployed on naval platforms. We talk about directed energy weapons, and again, lawfulness of these weapons themselves as opposed to the use of the weapons, whether such weapons should or should not be used is all covered by us in the manual. And I don't think the development of weapons is going to stop. The weapons manufacturers are always looking for some new capacities to be able to put on board vessels. But it needs to, they all need to be, if they are put on board vessels, they all need to be assessed for their legality as part of that process. And that's something that is part of the questioning, I suppose, of when weapons are developed, of whether they are in fact lawful or not. But we do talk about those issues in Chapter 6, and in the updated Chapter 6 in particular, you can see in the online version, you can see what we say about that. Coming to the conclusion that having gone through that assessment process, the answer of whether the weapon is lawful or not is answered as part of that process. All right. I don't think I wanted to say anything more about weapons. Has anyone got any questions or comments about anything that we cover in Chapter 6?